before I start, I'm sure you'd all like to join with me in thanking the wonderful Kate for putting all this together. That way I've got a decent chance of being invited back. No, thank you very much indeed. We've lost the light, have we? It's got to cool down before we can switch it back on. Sounds like me. Right, okay. Well, whilst it's cooling down, you have sort of got a copy of my presentation, but I've changed it since. So I think the theme of the sort of next half hour, and I think it's been a theme running through the whole day really, is that in order to be effective advocates, in order to both help people who've got capacity to speak up for themselves and in this very, very difficult world, access some of the services that they so desperately need, but also for people who aren't able to do that, your knowledge base, your understanding of the law, your understanding of people's human rights, really, your role is inextricably linked with that. You know, I'm sure, I go back to 1970 with my experience working with Advocacy, which is a while ago now. And, it's developed so much. And I'll be talking also a little bit about the risks and dangers of you becoming sort of a quasi-social service. Ooh, even hurts to say it. Right, nearly, we're getting there. I'm warming up. One of the things that you've got in your pack is a little sort of A4 sheet of paper that's headed Keeping Up to Date. Because some of the stuff I'm going to talk about is actually stuff that's actually happened literally in the last few weeks. I'm sure some of you will have read in the papers of the Peter Jackson, the judge deciding that a man with a gangrenous leg who lacked capacity, it was in his best interest to keep his leg on and die, and I'll be talking about that in a moment. Things are developing very quickly. So on that sheet, I particularly draw your attention to a guy called Jonathan, Mental Health Law Online, because first of all he's free, which is not a word that lawyers use very often, and also you can set it in a way so that you get an email from him every time you post something new. So you don't have to keep looking, it comes to you. Which for me is one of the most valuable tools around. So I would commend you to that. And there's also reference to how you find people like Lucy Series, who was referred to earlier on. So what I've been asked to do essentially is to look at sort of recent developments, what the judges have been saying, and also just talk a bit about the difficult tension. Have any of you ever been a litigation friend? Put your hands up if you've been a litigation friend. Yeah, one or two of you. You bastards. You've sold out. I mean, I have to say, as a solicitor spending most of my time in the Court of Protection, give me an IMCA in particular as a litigation friend any day of the week for all sorts of reasons. But the tension that creates, because it turns you into a decision maker. It turns you into the person that instructs the solicitor. It turns you into the person that decides even whether the case proceeds. Now, that's fine, and you are really well qualified to do that, but that is not advocacy. So there is that tension, apart from the fact that you're not commissioned to do it either. But please don't let me put you off doing it, because we lawyers need people like you, particularly with the official solicitor going into meltdown. So a little bit about that. I just want to remind you of the case of Colonel Munjaz. All right, it was a long time ago, it was 2005, but that was a case where the House of Lords, now the Supreme Court, basically was looking at how legally enforceable are these codes of practice, the Mental Health Act, the Mental Capacity Act, Deprivation of Liberty Safeguards. And what they said essentially was that people who make decisions, those codes are statutory codes. Those codes are part of the procedures prescribed which allow us, the citizen, to see whether agents of state control, which is another term for public authorities, not mine, unfortunately, Baroness Hale invented that one, whether agents of state control are actually acting in accordance with the procedure prescribed by law. That's what protects our human rights from the exercise of power by the state. And it's very interesting because those of you, particularly the IMHUs amongst you, can I still call it the new Code of Practice to the Mental Health Act, has really embraced Munjaz. Because, I mean, there is a diagram in the new code that basically says where the code uses the word must, it reflects a legal obligation, there are no exceptions, and that's got to be done that way. If the code uses the word should, then people have either got to do it that way or have a damn good reason not to. So, and of course, the whole of the new Code of Practice has been signed off by the regulators, and are, very much forms a part of inspections. I decided just to sort of have a little muse about what's been the implication for all of us of what happened on the 19th of March last year. Graham, where are you, Graham? Is Graham gone? Or is he? Oh, hello, he's sitting at the back there. Yes, Graham. You look more and more like Father Christmas every time I see you. Now, of course, Graham's the one that started this ball rolling when he and his wife Wendy were really, their love for Harry, whom they'd been caring for many, many years. Oh, how did you do that? You see, we need her, don't we? Led to the case, of course, in the European Court of Human Rights, which eventually led to the Cheshire West decision. In fact, people talk about Cheshire West as though it's some great sort of moment of sort of nirvana. Actually, much of Cheshire West was cut and pasted from the European Court's judgment in Harry's case, including the concept of the acid test. So it wasn't anything new. But 19th of March last year was really a tipping point. And the knock-on effect it's had for all of us has been enormous. I mean, did coroners see it coming? That, a death in custody has to have an inquest, and the definition of a death in custody is anybody subject to an authorization at the time they die. I mean, the implications for coroners has been enormous. We used to have things called informal patients under the Mental Health Act. Very few of them around now, or there shouldn't be many, because if a person lacks capacity, and many people in an acute phase of a mental illness aren't able to consent to their, in effect, deprivation of liberty, that means that if the acid test applies, if they're not free to leave, if they're subject to continuous supervision and control, and if they lack capacity, they are deprived of their liberty. Well, if they're deprived of their liberty, they can't be informal. And what that means is that AMPS can no longer, in exploring the least restrictive alternative, persuade those who lack capacity to enter hospital informally. That would be an unlawful thing to do, because you can't persuade somebody who doesn't understand the consequences of that decision to act in a way that is unlawful. So again, the ripple effects, continue to spread out. More children and young people are going to end up detained under the Mental Health Act, are already being, because the only real alternative is Section 25 of the Children's Act, and that really doesn't fit the bill in terms of recognising, once we recognise that a child or a young person is deprived of their liberty, how is it authorised? If the purpose of the deprivation is to deliver care or treatment for mental disorder, then what alternative have you got if they're in hospital other than to section them under the Mental Health Act? So, again, sort of the ripple effect of all this. You can see a reference there to more tribunals. There was a case in the European Court of Human Rights called MH, which basically said, we are discriminating against people who lack capacity, people who aren't able to say, I want a tribunal, I want to appeal, I don't like it here. Okay, well, the system works very well for them. But for those people who just are perhaps quietly unhappy, or perhaps don't have the ability through disability to appeal, they have to wait 6 months, and usually they'll be detained for less than that, so in effect they've lost the right to appeal. And then after that, another couple of months whilst it's organised. And the European Court said, too long. Too long. Okay. Now, I just want to share some very, very recent case law with you. And we all get very excited about the Court of Protection. I get very excited about the Court of Protection. And there's something very weird going on at the moment in the Court of Protection. I would call it the battle of the judges. They've sort of fallen into two camps. There's the sort of purist human rights, the Brenda Hale, the sort of Court of Appeal judges, and you'll see one of their decisions in a moment. And then you've got the pragmatists of the Court of Protections, the Mumbies, the Mostins, who are trying to make the system work and who seem to be trying to find ways of ignoring what the Court of Appeal and the Supreme Court have said. Which is a tension that's unique, I think. I've never come across it before, because our principle of case law is that judges in lower courts are bound by decisions of judges in higher courts. So there's some very, very weird things going on at the moment. So one can't actually predict too many of the outcomes from the Court of Protection. But this is a really important case where what Mumby was saying here, and this was very, very recently indeed, is that if you're going to go to the Court of Protection and you're, for example, arguing about what's in a person's best interests, it's no use putting up theoretical arguments. It's no use saying, well, what we think is in this person's best interest is to go back home, if the local authority is saying we wouldn't fund a care package in their home and they haven't got the money to pay for it themselves. So this really has sort of crystallised the view that, the Court of Protection can only choose between available options, which of course is very akin to the role of the best interest assessor. They can only choose between available options in terms of what might or might not be in a person's best interests. That was then followed by a case that slightly limited that. Again, you might have seen this case, it was quite well reported, of a guy who'd been in supported living for 9 years. And it suddenly dawned on North Yorkshire, oh, he's deprived of his liberty. We better get it authorised. So, supported living, nobody seemed to be really objecting. Off they go using the new procedures, expecting the court just to rubber stamp it. And the judge said, oi, hang on a minute. This guy's care, is it really in his best interests? I mean, for 9 years now, this guy in a wheelchair has not been even to be able to move around indoors because the doors are too narrow. He's had to crawl around the place to cope with that. Are you telling me this is in his best interests? Answer, no. So they had the temerity to bring a case to the Court of Protection where they weren't even arguing it was in a person's best interests. And the judge basically said, go away. I will not authorise this deprivation of liberty. Now, even though there wasn't a viable alternative, if I go back to the previous slide, what Mumby said in this case was where the right to liberty is concerned, this isn't about arguing between different options. If it's not in a person's best interest, end of story. The judge will not authorise it. And certainly local authorities have got to be careful, and you may well be acting as advocates in some of these cases. You may be the people that perhaps draw to the attention of the solicitor, if there's one involved, that actually, all these reports that appear to be wonderful, there are problems. Things aren't working well. These are the difficulties, and they've never worked well. Well, this is a case saying, well, in those cases, the judge will not... And of course, if you don't authorise a deprivation of liberty, this placement cannot continue. Because it was accepted he's deprived of his liberty. Somebody can't be somewhere where they are unlawfully deprived of their liberty. I mean, the courts are awarding around £1,000 a week damages for Mental Capacity Act unlawful deprivations of liberty. So these are cases that perhaps clients would like to take fairly slowly. Now, I'm going to spend a moment looking at this case from just a few weeks ago, because I think we can all learn huge amounts from what Peter Jackson says. This is the guy with type 2 diabetes. He's got a long history of mental illness. He's got some very fixed delusions about hearing the voices of angels and the Virgin Mary. He's been on his own for the last 5 years, and he has developed a condition that requires his leg to be amputated, and if his leg is not amputated, he will die. No dispute. And so the Wye Valley NHS Trust brought this to court, as they must, for a declaration that it would be in his best interests to have his leg off. Now, I think Jackson most probably approached this in a way that took a lot of people by surprise. And what I want to do is quote some of his words, because I think they're so important. Once incapacity is established, once we cross that line, so that a best interest decision must be made, there is no theoretical limit to the weight or lack of weight that should be given to the person's wishes, feelings, beliefs, and values. Now, let me just pause there for a moment. You know, we're all sort of wrapped up in this person's got capacity, third principle, Mental Capacity Act, we're all allowed to make unwise decisions, fine. But if they cross over into the world of lacking capacity, with our obsession, not your obsession, but with many people's obsession with safeguarding, which has got nothing to do with protecting individuals and all to do with protecting professionals, forgive me. But the reality is that what the decisions that are made in people's best interests are what decisions best protect the system from criticism and have very little to do with the emotional component, the wishes and feelings of the individual. The Court of Protection, time and time again, has been saying, we start with the wishes and feelings of the individual. And that's a crucial advocacy role, to remind, those famous words of Mumby. What's the point of making somebody miserable if all you do is... what's the point of making somebody safe if all you do is make them miserable? And I'm sure you've been involved in many, many people's cases who've been made thoroughly miserable by decisions to keep them safe. Yeah? So what the judge here is saying is that there is no theoretical limit. The wishes and feelings of a person are absolutely crucial in making a best interest decision. In some cases, the conclusion will be that little or no weight can be given, but in others, very significant weight will be due, as you can see in this case. This is not an academic issue, but a necessary protection for the rights of people with disabilities. As the Mental Capacity Act and the Convention, the European Convention, make clear, a conclusion that a person lacks decision-making capacity is not an off switch for his rights and freedoms. Now, there's a new little thing a new phrase that's entered our language. It's not an off switch. You don't switch off somebody's rights because they're assessed as lacking capacity. Too many people do. To state the obvious, the wishes and feelings, beliefs and values of people with a mental disability are as important to them as they are to anyone else, and indeed maybe more important. It would therefore be wrong in principle to apply any automatic discount to their point of view. I think it's important to ensure that people with a disability are not, by the very fact of their disability, deprived of the range of reasonable outcomes that are available to others. Now, reasonable outcomes that are available to us inevitably involve degrees of risk. That's what he's saying. The right to take risks, the right to have best interest decisions that involve risk. That's what this is all about. And that's what makes this in my view, such a radical and important decision. For people with disabilities, the removal of such freedom of action, as they have to control their own lives, may be experienced even greater affront. I mean, I was involved in a case just a couple of weeks ago. This guy phoned me and said, my mum was at home, she got a UTI, she's been taken into hospital. I've just had a phone call from the hospital, this was a Wednesday, saying that the doctors have decided that she's got to go into a care home, and I've got till Sunday to find the care home. And that was the conversation. No evidence of assessing mum's capacity, no evidence of what her wishes and feelings might be, not even any evidence of what her care needs might be to find the right care home. Sunday was the crucial thing. You've got to do it by Sunday. And then he phoned me. But I bet that's going on all the time. How do you apply those sort of principles to this sort of decision, which says the wishes and feelings of the individual are at the very heart of not the decision-making process, but the best interest-making process? In some cases, of which this is an example, the wishes and feeling, beliefs and values of a person with a mental illness can be of such long standing that they are an inextricable part of the person that he is. His delusions are real to him. They are his world. In this situation, I do not find it helpful to see the person as if he were a person in good health. And then this lovely phrase, it would be no more meaningful to think of Mr. B without his illness and idiosyncratic beliefs than to speak of an unmusical Mozart. It would be a nonsense. Further, people with Mr. B's mental illness are not uncommonly have what are described as religious delusions. As appears below, he appears to hear angelic voices that tell him whether or not to take his medication. Delusions arising from mental illness may rightly lead to a person's wishes and feelings being given less weight than is appropriate. However, this cannot be the automatic consequence of the wishes and feelings having a religious component. His religious sentiments are extremely important to him, even though he does not follow an established religion. And can I say that it just happens to be religion in this case? It could be a whole heap of other cultural beliefs or experiences. This just happens to be religion. There may be a clear conceptual difference between a capable 20-year-old who refuses a blood transfusion and an incapable elderly man with schizophrenia who opposes an amputation. But while the religiously based wishes and feelings of the former must always prevail, it cannot be right, in other words, perhaps a Jehovah's Witness, it cannot be right that the religiously based wishes and feelings of the latter must always be overruled, despite, of course, the fact that they're based entirely on a delusional component. This would not be a proper application of the best interest principle. Given the momentous consequence of the decision either way, I did not feel I could reach a decision without meeting Mr. B myself. So he goes along and meets Mr. B. He said the advantages were considerable, and indeed certainly it may well be, and very often in cases that I'm involved, particularly where an advocate is a litigation friend, it's the advocate that comes to me and says, Peter, I think in this case it'd be really useful if either the person was invited to court, if they were robust enough for that, or, as happens more and more these days, the judge goes to the care home. But I had a lovely case recently where the judge went to a care home in Hertfordshire, and there was a very, very pugnacious East End lady there who's, I couldn't even begin to repeat half her language. But she was very clear in her view about the fact that she didn't want to be in this care home. And the judge went to see her. And the judge walked into the room and explained, and the IMCA was there with the judge, and this lady looked at the judge and said, "Piss off!" Which wasn't, but in fact, that judge later went on to hold that that lady had capacity and had the right to make her own decisions, which was contrary to much of the evidence that had been presented in court. So here's a judge really throwing the door wide open to saying we must have much greater contact in the right cases between the judge who's making decisions, and this is the life or death decision in this case, and the actual visiting the person themselves. What the judge said was, what this guy said to me was really clear. I don't want an operation. I'm not afraid of dying. I know where I'm going. The angels have told me I'm going to heaven. I have no regrets. It would be a better life than this. I don't want to go into a nursing home. My partner died in one of those. I don't want my leg tampered with. I know the seriousness. If I'm going to die, okay, I don't want the operation. This is a judge with a life or death best interest decision. This isn't, as in many cases, does the person have capacity so they can make the decision themselves? This is a best interest decision. All this was said with great seriousness. So the balancing exercise, you know all about the balancing exercise, don't you? And of course, that's something as advocates you need to see evidence of. I'm quite sure it would not be in Mr. B's best interest to take away his little remaining independence and dignity in order to replace it with a future for which he understandably has no appetite, and which could only be achieved after traumatic and uncertain struggle that he and no one else would have to endure. There is a difference between fighting on someone's behalf and just fighting them. Enforcing treatment in this case would surely be the latter. I think that's really powerful stuff. And I think it really gives us strength you're an advocate, I'm an advocate. It gives us a strength as advocates to hold the system to account, to hold decision makers to account, and say, to what extent have you factored in the emotional component of your best interest decision? Show me the balancing exercise that you have carried out. Right. Now, in fact, I think I'm almost running over time, so I do apologise for that, but just 2 minutes, 2 minutes. You are really, really loved people, advocates. They don't want to pay for you, but you do your job properly. You're an absolute pain in the arse. But at the same time, now the state has chosen to create statutory advocacy, CARE Act, IMCA, whatever. That is your function, that is your role. And my worry, and some of you may have heard me speak a couple of years ago, when I was concerned, and I still am concerned, that as advocates, the state turns to you and asks you questions like, well, do you think this person has capacity? Sorry? What's that got to do with my role? What do you think is in this person's best interests? Sorry? And in a sense, the more difficult the case, the more or the alternative is that they turn to the advocate, consult with you, and then make completely the opposite decision and justify it by saying, oh, well, we consulted with the advocate, as though that made the whole thing all right. So there's a real danger that you sort of get sucked in to the system, and therefore, the purity of your role is absolutely crucial. And in terms of the knowledge you must have of the law, I know there's almost this sort of, the law, but one or two people have come to talk to me today, and I think everybody who's come to talk to me has felt better after talking to me. And that's not because I've given therapy, it's because people feel more confident around the issues that they raised because I was able to give a clear statement of the law. And that then allows you to go off and more assertively advocate on behalf of your clients. And I think it is vital that you as an advocacy movement and like-minded lawyers like myself see ourselves as part of the same process. And we learn to work together. And it's that working together that I would like to commend to you. Thank you very much.